and then direct the trial court, Judge McAfee, to immediately dismiss this case in exchange for the guilty plea to count 15, which would be entered, here it is, under the First Offender Act. That's their diversion program, thereby requiring count 15 to be quashed. He says it is simply beyond the jurisdiction of Fannie. You can't charge somebody for filing certain documents in a federal court. That's their problem. President Trump and his defense team are now turning their attention to Big Fannie Willis in Georgia. Remember, Trump was charged with racketeering, a conspiracy case related back to 2020. We know that Nathan Wade and Fannie Willis were colluding with the White House and meeting with people in Washington, D.C. And now that President Trump is going to be president again, he is taking these cases out one by one. Florida classified documents case, gone. January 6th case, gone. In fact, Jack Smith filed again to try to get it dismissed again. That's how badly he wants it gone. Alvin Bragg's case has not had sentencing yet. They vacated that date, rescheduled it for an evidentiary hearing, and we already previously read through Todd Blanche's filing that laid the proverbial backhand on Judge Merchan and his daughter. Even though there's a gag order, they splayed it all out on the filing for us to see, and it was great. Now it's Fannie time. She has no jurisdiction over this case. And the great Steve Sadow is focusing in Fulton County now. He says, all right, here's my comment as lead counsel for President Trump in Georgia. He said President Trump has filed a motion requesting the Georgia Court of Appeals confirm it has a lack of jurisdiction to continue to hear this appeal now that President Trump is president-elect and will soon become the 47th president of the United States. And then direct the trial court, Judge McAfee, to immediately dismiss this case. The filing states that any ongoing criminal proceeding against a sitting president must be dismissed under the U.S. Constitution. The two federal criminal cases have already been dismissed by the DOJ, and this one has to go too. Here's what Steve Sadow submitted. In the middle of an appeal, in the middle of the criminal prosecution of the president, we are on interlocutory appeal, which means the case is not concluded. We are pausing the case to take this up. The issue here is, should Fannie Willis be disqualified? Judge McAfee was so pathetic that he just said that she was a noxious odor, stinky person. So now we're in the Court of Appeals because they're both unhappy with McAfee's ruling. Now Trump is here responding, saying, listen, Court of Appeals. President Trump hereby notifies this court of a following jurisdictional issue. And if you don't have jurisdiction over something, that's it. The court has no power to hear it. Here's the problem. The unconstitutionality of President Trump's continued indictment and prosecution by Big Fannie is unconstitutional now that he's the president-elect. Now that he is going to become the 47th president, it impacts your jurisdiction. Now, you've said this court has always held, as we talked about in this case called Gonzalez versus Miller, which is not old at all. It's from this year, Your Honors. You said, just like months ago, that it is incumbent upon this court to inquire into its own jurisdiction. So you need to look into this. You admit it, you said so. On November 5th, President Trump became the president-elect again. On January 20th, 2025, that cannot come soon enough, President Trump will be inaugurated again, this time number 47, saying a sitting president is completely immune from indictment or any criminal process, state or federal. The Constitution forbids, quote, placing into the hands of a single prosecutor like Big Fannie the practical power to interfere in the ability of a popularly elected president to carry out his constitutional duties, saying even the Office of Legal Counsel wrote in a memo, quote, a sitting president is constitutionally immune from indictment and criminal prosecution, clear as day in black and white. Now, this doctrine has been well recognized since the dawn of the Republic until Trump came along. The president cannot be liable to arrest, imprisonment, or detention while he is in the discharge of his duties of office. After reviewing historical sources in case law, the Department of Justice reinforced this conclusion in the year 2000. They wrote this. They said, given the potentially momentous political consequences for the nation that are at stake if you indict the president, there's a pretty fundamental structural incompatibility between the ordinary application of the criminal process and the office of the president. Now, that's a fancy way of saying the president is the executive branch. Now, indeed, in full recognition of this immunity, the DOJ filed a motion to dismiss Trump's federal prosecution, both in the 11th Circuit, which is the classified documents case, and in the District of Columbia, which were immediately granted by both courts. They dismissed all the charges against Trump, and they did it quickly. Now, the Supremacy Clause that we know about in the Constitution, together with the principles of federalism and comity, friendship with the states and other entities, prevent state prosecutors from proceeding against the sitting president in any way. That came up in Clinton versus Jones back in 1997. They noted that a state criminal prosecution of a sitting president would raise federalism and comity concerns rather than separation of powers concerns, as well as the interest of protecting federal officials from local prejudice. They protected Clinton. They say states have no power to retard, impede, or burden the operations of the federal government. That's an 1819 case. This has been settled for a long time. And comity is this is, you're working in partnership, you're working in friendship together. Like the states and the federal government are not supposed to be at war with each other. And that certainly becomes the case when you have a state that's prosecuting a president or in the same country. As the U.S. Supreme Court reaffirmed in 2020, the Constitution guarantees the entire independence of the general government from any control of the states. It follows that states also lack the power to impede the president's execution of those laws. Now, under this principle, the Supremacy Clause prohibits state judges and prosecutors from interfering with a president's official duties. This is particularly true whereas here, there is compelling evidence of local bias from Fani and political prejudice against Trump by the big Fani, who not only answers to a tiny segment of the American electorate, so she has more power than Trump does. He just got elected by the nation, and Fani is in Fulton County in Georgia, but is acting in clear opposition to the will of the citizens, as Georgia as reflected by the election, which went red and voted for President Trump. Even harassing subpoenas could, under certain circumstances, threaten the independence or the effectiveness of the president. If a sitting president is intensely unpopular in one district, like in New York, and that is a common condition, targeting the president may be alluring and an effective electoral strategy, like in DC, which voted 93% for Kamala. But it is a strategy that would undermine our constitutional structure. Judge Alito wrote this in a dissent. He said, unlike impeachment, the most important decisions in the process of criminal prosecution would lie in the hands of unaccountable grand and petite jurors, deliberating in secret, perhaps influenced by regional or other concerns that are not shared by the general polity, by the nation as a whole, guided by a prosecutor who's only indirectly accountable to the public, like Bragg or Fani. So accordingly, Trump's defense says, well before the inauguration of President Trump even happens, it's coming soon, this Court of Appeals in Georgia should inquire into its jurisdiction. Can you even hear this appeal? You have no authority. That inquiry that you said you should do should result in this court deciding that both this court and the trial court lack jurisdiction to entertain any further criminal process against President Trump, as the continued indictment is unconstitutional. Trump respectfully submits that upon reaching this decision, this court should dismiss his appeal for lack of jurisdiction and directs the trial court, Judge McAfee, Weenie, to immediately dismiss the indictment against President Trump. And of course, signed by Steve Sadow, who we saw just crush the last time we were here covering the disqualification hearing some time ago, sent fresh out of the oven December 4th. So this will go to the Court of Appeals. We'll see what they say about it. Remember this guy. We talked about him and his plea deal when he took what I read as a diversion plea deal. Fani Willis, as far as we can tell, and I know there's other Georgia lawyers who disagree with me, and there's other people who disagree with me, who say that what we read in their own filings was that Kenneth Chesebro's, Sidney Powell's, and Jenna Ellis's plea deals were diversion deals. So what happens is you get a guilty plea, but you don't have a sentencing that occurs. You put the case basically in abeyance. You come back after a short term of probation, and then they dismiss the case, and you do not have any guilty plea or any guilty conviction. That's how diversion works. But this is Kenneth Chesebro, and even though he was going to get that deal, he still wants to undo the plea deal. So he submitted a filing into the court saying that my charge is unconstitutional. Here's what he wrote. He says, all right, in the Superior Court of Fulton County, we're back in McAfee's courtroom. Kenneth Chesebro says, all right, listen, Your Honor. Kenneth Chesebro is now here with a plea in bar. Now, that's a legal challenge to the validity of an indictment. It's not a common thing that you see. It says, when a plea in bar is when the defendant shows by matter extrinsic of the record that the indictment is not maintainable. Now, generally speaking, this court retains jurisdiction over Chesebro because he's on probation pursuant to the diversion rules. Now, Article 1, Section 17 of the Georgia Constitution provided that legislative acts that are in violation of fundamental law are void, and if it is unconstitutional, it cannot stand. So with that being said, he says, now we're challenging count 15. This request is predicated on the court's order which found count 15 previously invalid back in September. Now, on October 20th, the district attorney offered to dismiss 6 of the 7 counts in exchange for the guilty plea to count 15, which would be entered, here it is, under the First Offender Act. That's their diversion program. Mr. Chesebro agreed to this resolution, and his guilty plea was accepted and entered by the court. Now, in Georgia, a defendant cannot plead guilty to a charge that does not constitute a crime. Makes sense. By pleading guilty, Chesebro waived all defenses except that the indictment failed to charge him with a crime, saying, in this regard, if a defendant can admit all the allegations contained in the indictment, yes, everything that you wrote in there is true, but you didn't articulate a crime. You can have an indictment filled with all sorts of garbage. but did you articulate the elements of something that's a crime or actually criminal? They say no. The indictment has failed to sufficiently say that Chesebro committed a crime. There's another case that says if the defendant can admit every allegation in the indictment, so everything they claim is true, but there's no law that any of those things that they claim are true is illegal. Now, although this motion is titled a plea in bar, another vehicle for relief is a motion in arrest of judgment, another mechanism to file a post-conviction challenge the validity of the indictment. They say in Georgia, we also have this case. It's called Wood versus State, written back in 1871. We also filed another motion to dismiss count 15 under the Supremacy Clause back in September. Now, a plea in bar is a challenge to the validity of the indictment, and this mechanism can be utilized post-conviction. They say count 15 was a conspiracy count under Georgia law 16-4-8. The conspiracy was predicated on another portion of the law, which in relevant part purported to make it, quote, this is what Fannie charged in the indictment, make it unlawful for any person to knowingly file, enter, or record a document in a public record, knowing that it contained false statements. Count 15 in Fannie's indictment said that Chesebro was one of 10 co-conspirators connected to the filing of the electoral votes to the federal court, right? So Chesebro sent a document into the federal court. Well, this is curious because the federal court, isn't that a federal crime? Why does Fannie have jurisdiction over sending something into the U.S. District Court for the Northern District of Georgia? That's the federal court, not a state court. Fannie doesn't have jurisdiction to pursue crimes against them. On September 12th, this court, McAfee, held that count 15 being predicated on Georgia law is unconstitutional. The reason being is that federal law preempts the state's ability to prosecute perjury and false filings in the federal court, thereby requiring count 15 to be quashed. He says it is simply beyond the jurisdiction of Fannie. You can't charge somebody for filing certain documents in a federal court. That's their problem. As a contrary holding would enable the state to constrict the scope of materials that are assessed by a federal court, and it would impinge upon the jurisdiction of that court. So it's their business, not yours. So beyond the requirement of Georgia law that Mr. Chesebro's plea be voided, since Fannie charged him illegally, and count 15 be dismissed forthwith, a failure to grant the relief would also violate Chesebro's due process, saying it's not okay to allow a person to serve a sentence for a crime that is not a crime. An unconstitutional law is void. An offense created by it is not a crime. A conviction under it is not erroneous. It's illegal. Here, Chesebro says the charge that McAfee says is unconstitutional that he pled guilty to is invalid, and it has to go away. Signed by Manubir Aurora, attorney out of Georgia. Shout out on a good filing from Manubir, sent in on behalf of Kenneth Chesebro.